Good afternoon, everyone, and welcome. I'm Susan Anderson, and I am the chair of the Education Law Subgroup at Roetzel and Andress. And on behalf of Roetzel and Andress and our team here today, we want to thank you for joining us for today's webinar, Breakdown and Analysis of Critical Provisions in the 2025 Budget Bill and their impact on Ohio school districts. So I'm guessing that many of you, if not all of you, have heard that Governor DeWine signed the budget bill last night at about 11:15 p.m. And along with that came 67 vetoes from his office that weren't released actually until early this morning. So, full disclosure, we've had to pivot a bit on our agenda today to address the content that was vetoed. And as a result, we do not anticipate that this webinar will go the full 3 hours as we originally scheduled. I also don't anticipate there being a lot of complaints about that from attendees, but if that is an issue, I do apologize for that. As we'll discuss, many of Governor DeWine's vetoes are good for school districts, good for you all. But the final budget bill does still include a wide range of issues and provisions that will directly impact your districts. So our goal here today is to help you understand what's been left in the final bill, what got vetoed, what may be subject to override, and ultimately what steps you all can take from here to address the legislative changes that are in the budget bill. Because of the late night vetoes, our content has been reduced, and instead of structuring the webinar in two parts where we address the funding provisions in one part, have a break, and then address the other provisions, we've just combined it into one segment, and we'll have a Q&A after that. And we're anticipating really this segment to go maybe an hour and a half or so. Joining me today for the discussion are my colleagues, Kathy Perrico. Kathy is a shareholder in our education and public law groups here at Roetzel and Andress. Also joining us is Sherri Warner. Sherri is a director at Roetzel Consulting Services, our legislative component of our firm, and she's also of counsel, an of counsel attorney with Roetzel and Andress. And Sherri really is the lifeline of all of what we'll be talking to you today. So special kudos to Sherri for all of her hard work and helping get all of us up to speed for this webinar. And then last but certainly not least, we have Aaron Ross joining us. Aaron is an associate in our Columbus firm, our Columbus office rather, and Aaron also practices in education and public law. So just before we begin, a few housekeeping items. This webinar is being recorded, and a copy of that recording along with the presentation materials will be made available to everyone after this event. So keep an eye out in your email for that. And then, as I mentioned, we'll be doing Q&A after the substantive discussion of the bill provisions. And so if you have any questions at any point, go ahead and enter them into the Q&A box, which you should be able to see at the bottom of your screen. And then we'll address those questions at the end. So with all that said, thank you again for being here, and we'll go ahead and get started. And I'm going to toss it to Sherri.
Good afternoon. So again, thank you for joining us. I too thank the governor for making this part of our webinar very short today. I am sure that all of you are thankful as well. Here is a list of the vetoed provisions that the governor provided. He has made these vetoes because he believes it's in the public good. He did state in a press conference at 10 o'clock this morning that he felt that the property changes were too much too quickly for the school districts to be able to manage, which is why he chose to veto those. And then he felt that the library restrictions were unenforceable and not able to be useful in this space, and that was why he chose to remove or to veto that provision. So he did make changes to what levies you can assess or you can put on the ballot. If you remember correctly, the budget eliminated all of those. The 20 mil floor calculations, he changed that. So we're not going to have all of your emergency levies and those types of levies counted into the 20 mil floor. He got rid of the county budget commission legislation or language. And this would have been the language that would have done a couple of things. One of them is it would have enforced the carryover restriction, which he also vetoed. So as of today, there's no carryover restriction on what you can have from year to year. Um, and the county budget commission does not have the authority to reduce your levy because of a carryover amount. I will tell you that the county budget commission language, there are some questions in the state as to whether the county budget commissions can unilaterally reduce levies already by the authority they have. We have some county prosecutors that have determined that they could just go in and reduce these levies should they want. We've had other county prosecutors say they don't have that authority. So if your county prosecutor or your county budget commission starts to take action, understand that they potentially believe that they can. That will lead to some confusion across the state, and I'm sure that will be something that'll have to be addressed by the General Assembly. Their reasoning for putting this language in was to make it absolutely clear that the General Assembly's intent was that these county budget commissions would have this authority. I will tell you in that space, one of the questions that kept coming up and was problematic was the fact that we have so many school districts, and I think it's like over 200 that cross county lines, which means in essence, they would be subject to more than one county budget commission. And I know that I heard answers to that question being what would be the largest county that would control. But then that leaves significant issues for the members of the other counties who would not have a voice in what this commission was doing to their local school district. So we will be watching for that. As I said, excuse me, he did eliminate the carryover restriction. The library restriction was it for the public libraries, but because some of our schools, our school and public libraries together, we wanted to make you aware of them. This was the restriction on where you could have gender ideology and sexual identity material within the view of minors. And so that provision was vetoed. We are going to keep our school board races, at least right now, as a nonpartisan. The ESC races will also be nonpartisan. I do want to point out that he did not veto the changes to the state board. So under this bill, the state board will become an appointed body of 5 members, and the current elected members will come off of the board as their term ends. So that's going to be a transition process. But then after that, the governor will appoint the 5 members to the state school board. The biggest one, I think, personally for all of you, is that he did veto the STRS, SERS contribution pickup prohibition. So this was the provision that said that boards were prohibited from providing or paying the employee's share of their retirement contribution, but that restriction was only on superintendents, treasurers, and building principals. That language was stricken, so your contracts that have pickup provisions in them will remain in place pending an override vote. Discussing that, just so you are aware, the override process. The override process allows the General Assembly to override the veto of a governor with 3/5 majority in the House and 3/5 the majority of the Senate. So you have the numbers. This equates to 20 out of 33 senators and 60 out of 99 House members. The veto will have to start in the committee where the bill originated, which means in this case, the House will have to be the first one to take up the veto override. If they override the veto on their vote, then the Senate would be able to come in and override it as well if they would have the votes to do so. But there's no restriction on the time. So they could override this veto tomorrow. Well, they can't tomorrow because they haven't put a notice out for meeting, but they could override this veto on July 15th of 2025, or they could override these vetoes on November 8th of 2026. And the reason I make that statement is that I know that a lot of you are taking a breath and sigh of relief, and I think that's great. And we have another 2 years to kind of watch this process and hope some things come out correctly. However, I do anticipate that the next governor may not act in the same way that this governor did, should it be a Republican candidate. Right now, it looks like the Republican nominee is going to be Mr. Ramaswamy. And he has indicated the need for property tax reform. The other issue is, I mean, we also could have a governor from the Democratic side. Their candidates, obviously, they have Dr. Amy Acton as a candidate right now, but I anticipate others joining that race over the next probably 6 to 8 weeks. So we'll have to see where that comes down to. But saying all of that, the governor's vetoes could still be overwritten after that election result is known. So be aware of that. Saying all of that, the governor did state that he is very concerned about property taxes. He has heard the complaints, the issues, the concerns about property taxes, and he's putting together a committee to address property taxes, a task force. They will be working and coming up with what he views are some solutions to this particular issue. So we'll see what comes of that and who he appoints to that committee as they move forward. There has been criticism already in social media of the governor's decisions in this space. There's not been any type of official response from the Senate president or the speaker. So we aren't sure exactly what they're going to do yet. I'm sure they're huddling and we'll have some conversations and decide where they're going to be. I do know that they still have concerns over the proposed constitutional tax amendment, which would prohibit all property taxes. So they feel that something needs to be done, and whether it will be an override of one of these provisions or an attempt to pass a version of House Bill 335, which was the bill that much of this was pulled out of, that was introduced in the House in the last 2 weeks of the General Assembly, or the last month of the General Assembly. We could see that bill now becoming active and moving. Clearly, I think there will be significant changes in its content should that start to happen. Finally, on my side, real quick, we'll run through the school fair funding formula. Despite the House saying that they did not intend to have this formula be the formula into the future and to have it continue, they did in the end agree to keep this formula in place and to phase in years 5 and 6. But obviously, they're using the same cost data that they used in years 24, which means that they did not update that data, which would have increased significantly the amount of money going to schools. Just some other highlights so that you're aware of it. The formula does eliminate payments for gifted professional development funds, and it eliminates the targeted supplemental assistance. They did, in the end, keep all of the guarantees and the caps in place. So if you're in that space, you will continue to receive 100% of those funds. They increased the minimum state share of transportation, which should help provide you with some funds towards the transportation challenges that you all have. And they add an enrollment growth supplement to the formula to target money, I think, towards those districts, or to help those districts that are seeing high growth. So with that, you can see a couple of other changes in the funding formula, and I will turn it over to Kathy, who is going to do the scholarship programs.
Hi, everybody. Again, echoing the thanks for joining us, which has been quite a whirlwind. I'm sure you were following things last night and into this morning. So, again, thanks for sticking in there, even though there were a whole bunch of changes and a whole bunch of scrambling to get this content adjusted for you. So switching away from funding models in a way, but yet there's a link. I want to start off by talking about the changes to the scholarship programs. So here we've got some expansion of who's eligible overall. We don't just see parents in the language anymore. We have custodians, guardians, grandparents, surrogate parents, and the eligible child if they are between 18 and 22, but not under guardianship. You guys are probably going to have a rough go of it navigating some of these applications that are coming in from non-parents in terms of being able to verify that they do have the right credentials, they have true guardianship, um, they have, they were appointed as a surrogate parent by the district, etc. The autism scholarship was 3 through 22. That's not news. Peterson is now expanded to 3 and 4-year-olds. So there's an expansion of just how many students can access the Peterson scholarship there by age. There is another category of children, and this one is going to be a little tricky for the next 90 days. So here we have the legislature covering the gap that existed for homeschooled kiddos who were over 18, right? So if you are in a chartered, non-chartered, if you're home educated, if you're between 18 and 22, or if you're still eligible for transition services, and for autism kiddos, you still have to have an IEP that includes services related to autism. We got no clarification on what that means. One could argue that is indeed anything. But here that closes the gap for children who are originally becoming ineligible if they were home educated after the age of 18. Um, what we're going to have to be concerned about is for students who were in this category. I've already had calls, actually coincidentally having nothing to do with the budget bill, regarding some providers who are notifying the students that they're no longer eligible because they're home educated and were over the age of 18. So you might see not necessarily a flurry because I don't have numbers on how many there are, but you might start getting questions from parents about what the heck they're supposed to do in the gap between the student being 18 at the start of the school year and 90 days from now when this provision becomes effective. This one is a little bit of heartburn. So the changes in who can provide services are fairly expansive. Okay. Now anything can be virtual. There can be a multiple, like an amalgamation of providers that parents can smash together under the scholarship. And now aides, instructional assistants, credentialed providers, and substitute teachers can provide virtual services. There is a layer of oversight alluded to in the language, but it's not great. So there will be an expanded amount of providers who can submit for billing. It's still my understanding that for any provider serving a student virtually under the scholarship, one of the criteria for reimbursements will be that they provide a log of service minutes with a detailed accounting of what they were working on. I have no indication that that has gone away, so that should provide some solace. Scholarships increased, not too terribly dramatically, but every dollar counts, right? So all of the categories in JPSN increased incrementally, and the autism scholarship jumped up to $34,000. Okay. JPSN now goes from a low of just over 2,000 to just under 32,000, yet with a cap of 34,000. So not quite clear on why the cap would be over the 31,932. That applies to category 6 students, but that was written in. Okay. So science of reading and screenings. And the governor spoke specifically in his press conference today about being very proud of the continued efforts of the legislature and of his whole team surrounding reading intervention and reading initiatives for students in Ohio. One of those changes this year, we have everything that currently exists, and now the one little add-on is the department needs to have an intro professional development course that every teacher, this one is interesting to me, school psychologist or speech path that needs to complete training in the topic of the science of reading on a 5-year basis. For teachers that snuck in and got hired before July of this year, they have 5 years to complete that professional development. If you're, for example, a new grad or you transfer districts, if you were hired after July 1, you have to do it within 1 year, unless, for example, you completed a similar training in an earlier district, or for those recent grads, if you had some level of science of reading training as part of your preparatory program in your college or university setting. The professional development has to align with the grade bands that you are assigned to and the subjects that you will be taught, and it will get to count for licensure renewal. So that first part of that, right, is intended to eliminate people jumping on and taking any training to check the box, whether or not it was appropriate to the grade level of their assignment. Districts have some reporting obligations here. So they need to report the number of individuals that complete the training in EMNIS. We don't have details yet on whether there are more details that will need to be put into EMNIS, for example, to verify that the staff member who is taking credit for the training attended a training at their grade band of applicability. Okay. So here, more science of reading information and screening information. The department, just one day under a year from now, has to adopt a diagnostic in reading only, but then have an approved list of 5 assessments for reading and math. Okay. Districts have to administer the diagnostic assessment in both content areas beginning with the 26-27 school year, right? So if you remember when the dyslexia provisions came out, they were squeaking in under the wire or late and then granting us extensions because the department didn't have their layers in place. But presuming that they get their layers in place by June 30th, we have to, by the beginning of next school year, administer these diagnostics. Now, this last sentence is generic. Intervention must be provided. That's in both. There were provisions as the bill churned through the process for math intervention to be tied to a math monitoring and improvement plan. That provision got stripped, but the requirement to provide math intervention for kiddos scoring low on the diagnostic was not eliminated. So more details and specifics we are presuming will come from the department in that regard. Okay. The Department of Ed no longer has to make the assessments themselves available to the districts at no cost. Okay. But slight twist on that, the universal dyslexia screening measure that they need to identify by this January must be made available to districts at no cost. And that universal screener has to be implemented by the start of next school year. Okay. And with that, I'm going to take a little breather and let Aaron jump in and tell you about the math enrichment requirements.
So we've gone from science of reading, now logically go to math here, and I'm going to drop in just for the one slide, and I'll be back to kind of talk with you a little bit more and a handful more slides. One of the big changes is this math enrichment idea that made it into the bill, and districts are required to provide, if they have them, advanced math learning opportunities for students who are exceeding grade level standards. Those students are going to have to take the year-end assessment that's consistent with the course that they took that school year. So if they're in that advanced course, right, they can't take the end of the year exam for the course that they should have been in, maybe in line with their grade level. And it gives the parents the ability to opt their child out of the advanced classes. It defines the advanced math opportunities to mean learning opportunities or a course that provides academic content or rigor that exceeds the standard mathematics curriculum for the student's grade level, including a mathematics course that is 2 grade levels above the student's current grade level, and that's as determined by the district. Those advanced levels are to be determined by the math assessments pursuant to the revised code, and that statute is going to incorporate, right, all of your end of the year mathematic exam assessments, I think beginning on 3rd grade. And then eligible students will be provided the advanced courses in the following year. And then whether a district has those advanced math learning opportunities is dependent upon whether it offers those advanced learning opportunities in mathematics or an advanced mathematics course for the grade level in which that student is enrolled in for the next school year. So I think the moral of the story here with this one is if your student is testing into that advanced class and you have the advanced class, the student needs to be placed in there unless the parent opts them out.
Thanks for the breather, Aaron.
Absolutely.
So more on the universal K-3 diagnostics and the kindergarten readiness assessment. So again, the department has to adopt a diagnostic for reading by June 30th of next year and provide that list of 5 diagnostic assessments that are in alignment with state-approved content standards for both reading and math. The 3 reading diagnostic assessments that are approved by Due for Use will be comparable tools to the 3rd grade reading guarantee. The reading diagnostic assessments must align with the science of reading. And it was very clear from DeWine's press conference today that that his team is fully on board with the science of reading. This is not new. I just want to re-highlight that. There was some language in the bill specifically disclaiming and discrediting any district is now officially cautioned against still attempting to use a 3 queuing system. It is all about science of reading. There won't be exceptions. So to the extent that you are still trying to hang on to some other system based on your scores or some other outcomes, that's gone. The assessment that districts must do for students needs to be by September 30th of each year. Apologize for that missing word, beginning with next school year. And again, other than that dyslexia screener, the department does not have to make these available to districts at no cost to them. So again, the prior exemption that lets schools on a case-by-case basis not annually administer diagnostics to assess the reading skills of a student with a significant cognitive disability as part of the 3rd grade reading guarantee, that's gone too, right? And it removes the authority of districts to use an alternate assessment to measure reading skills under the 3rd grade guarantee. So I will skip my personal commentary on this one, but that statement alone probably tells you how I feel about the removal of those exemptions. Consult with your own counsel regarding what that means for when you are discussing and completing Section 10 of your IEPs. Just like you do with any other alternate assessment, right? It's still a team discussion and decision in some ways, but you've officially been told you're not supposed to be doing that. Districts that have achieved specific scores on the state report card don't have the ability to administer alternate diagnostic assessments. Again, specific nod in that language to the 3 queuing system, no matter how high achieving you are. Districts need to use and score the KRA in accordance with rules that will be established by the Department of Children and Youth. And it eliminates the requirement that the department include data from the KRA on state report cards. Okay. So that's maybe one little happy fact in all of that reading and math screening and diagnostic assessment content. Cell phone policy. I'm half hoping my son doesn't hear that and jump up and decide to start yelling about the cell phone policy going into his senior year that he absolutely thinks should not apply. But here, this went through. We all know this was a big pet of DeWine before even this budget bill. We had permissive language in place. We shifted to required language here. So here's what's interesting in terms of the way this has been discussed in the media, discussed amongst you all based upon those media statements. There's slight variations on what we thought we knew. Okay, so the first big thing here is schools may adopt a policy that says we are a cell phone free campus, right? No buildings, no grounds, no facilities that we have rented or contracted with for use for any educational purpose, right? So if you're using the city's rec center for your tennis matches because you don't have your own courts, you could in fact prohibit cell phones even on that property. That's pretty huge, but it is available. And if you do adopt such a restrictive policy, you've got to make it available to students and parents upon request. I would suggest that you don't wait for the request, that it be absolutely front and center on a website, in handbooks, and as required, posted in a central location in each building. And here's the must part. Okay, by January 1st, so you've got a semester to work with your policy service to have internal conversations, because I am quite certain your policy services will all give you select options to choose from when they provide you with draft policies. You must adopt a policy that prohibits use during the instructional day, except to monitor or assess a health concern, if a written statement by a physician requiring such use has been provided. Okay, so this would be, for example, your blood sugar monitoring apps for students with diabetes. If, and there was a lot of media conversation around in case of emergencies, right? And everyone was scratching their head going, well, how are we making sure that we get students back to their phones if there's an emergency, if we're on lockdown? So that's not actually the way the language is built into the law. It's if the building's comprehensive emergency management plan, adopted under the specific statute on your screen, permits such use during the course of emergencies. So that might help alleviate some of the angst about how you're going to get students back in contact with their cell phones in the event of an emergency. And then the third exception would be if the student's IEP or 504 plan includes the use of a cell phone or other electronic communication device. The way electronic communication device is worded, I could argue both ways in terms of whether the trackers and the Angel Sense devices count. So again, if that comes up, I mean, first of all, I would generally caution that writing these things into IEPs or 504 plans should be a rare occurrence. But if it is written in, contact your counsel to really analyze what this new bill means for those purposes. And then in terms of educational purposes, the language that previously existed went from mandatory to permissive. So boards can permit students to use cell phones for educational purposes, right? Boards, as we know, aren't making these decisions on a day-to-day basis or class to class or unit to unit basis. So that's where your policy language is going to need to work really hard to identify what that board permission looks like, and then how teachers will act under the authority of that permission should they want to let students use cell phones within their class periods. Here, kind of different language, but if you've got any policy, right? So whether you've got the really heavy hitting one or whether you've got the more limited one, any policy about cell phones has to be prominently displayed on your publicly accessible website if it has one. I don't know. I'd love for somebody to tell me if there's a district that doesn't have a website yet, but you all have to have it posted prominently on your website. So I would suggest working with your IT group and figuring out what's prominent and how you can make it easily accessible to families, because I guarantee that you're going to get 5,693 phone calls between now and January 1st about what people want to see in this policy. And then after January 1st, you're going to get 10,224 calls about why you got it wrong. So go ahead and make sure that they have it readily accessible so they can call you and render all of their criticisms. And I might be frozen. If I could have an assist trying to advance the screen, I'm going to go ahead. Sorry for our guests. Okay, looks like somebody else has it.
So I'm going to take over here for a little bit. We're going to talk about handful of different topics, starting with the disadvantaged pupil impact aid. So the disadvantaged pupil impact aid, the funds under this use the same formula as they've been using, and really we've got a really small change to this, and it's focused on the required plans that school districts must have for use of these funds. And so when we're talking about those plans, they have to be done in coordination with at least, one of the following in the list. And so there's a small change here where we're going from a community-based mental health treatment provider to a community mental health prevention or treatment provider. So a small change there, but in terms of the wording, but I think designed to include more more treatment providers or prevention providers to be able to coordinate with this. So that's going to be included there as one of the partners that school districts are allowed to coordinate with that. So the next up is a performance supplement, and the title might be a little bit misleading, not talking about protein or anything like that, but actually additional funds for school districts who have met certain criteria. So this part of the bill creates a performance supplement for 2026 and 2027 for school districts who received any of the following on their 2023-2024 report card. So we're talking about, fiscal year 26 and fiscal year 27, but focusing on last year's report card. So if they have an overall performance rating of 4 or more stars, a performance rating of 3 or more stars on the progress component, or a higher performance rating on their progress component than the district received for that component on its 2022-2023 report card. So they're looking at whether you've improved in that time frame, and if you meet any of those three criteria, then you're eligible to receive the performance supplement. Now, this performance supplement is calculated as equal to a school district's current year enrolled at ADM, the average daily membership, then multiplied by the greater number of stars the district received for either their overall performance rating or the performance rating for the progress component on the state report card, and then multiplied by $13. So those number of stars that we're talking about, can range between 1 and 5. So based on how well the school district does, we'll determine that multiplier there, and whichever one is higher. So if you have a higher performance rating for the progress component, let's say you get 5 stars, then it would be multiplied by 5. So that's going to be in addition. Initially this was part of the actual funding. They moved it to its own funding line and kind of outside of the funding towards the end of the bill process here. Administrative expenses are curbed in the bill as well. So it adopts a new statute prohibiting any school district from expending more than 15% of its annual operating budget on administrative salaries and benefits and other costs associated with the district's administrative offices. So the fiscal notes on this were pretty specific that there's not many school districts who are over that threshold, and that for those that are not, the provisions are really not going to have much of an effect on their operating budgets or their expenditures. So one of the big changes is actually to absence, intervention, and truancy. One of the things that we're going to see here is almost a deregulation. The changes in this policy, there's structure to it, but really kick it back to the school districts to develop their own process and procedure for handling absence, intervention, and truancy. So the first thing to note is it repeals the requirement that a school district assign a habitual truant students to an absent intervention team and adopt a prescribed absence intervention plan. Now, it doesn't mean you can't do that. It just means you don't have to do that. So instead, it requires each school district to adopt a policy by August 1st of 2026. So we've got a little bit of time here to work on the policy. And you have to collaborate with the juvenile court in the county in which the school resides, the parents, guardians, or other persons having care of a student attending school in the district, and then appropriate state and local agencies. Now, this policy, the bill, lays out kind of the structure of what needs to be incorporated. There has to be some sort of acknowledgement that student absences from school, really for any reason, whether it's excused or unexcused, takes away, impacts the student, and takes away from that instructional time and has an adverse effect on student learning. The policy has to identify strategies to prevent students from becoming chronically absent, and then include procedures for notifying a student's parent when the student has been absent from school for a number of hours determined by the board, which cannot exceed 5% of the minimum number of hours required in the school year. So to dissect that a little bit more, the school gets to choose the number of hours that they want to include in their policy, but it has to, it can't, that number of hours can't exceed 5% of the minimum number of hours. So I think, kindergarten, full day kindergarten through 6th grade, 900 hours. So can't exceed, 5% of that. 7 to 12 is 1,100 hours, can't exceed 5% of that. So we're talking about the statutory minimum requirement, not necessarily the school district's number of hours required in the school year. So the policy also has to establish a tiered system that provides more intensive interventions and supports for students with greater number of absences, and includes resources to help students and their families address the root causes of those absences. So, focusing more resources on those individuals with higher number of absences, and increasing those resources as the students' absences mount up. The policy also has to provide for one or more absence intervention teams to work with students at risk of becoming chronically absent and their families to improve the students' attendance at school. And then finally, the policy has to prohibit the suspending, expelling, or otherwise preventing a student from attending school based on the student's absences. So can't send the student out of school more for missing school. Further changes to this, implemented by the bill, is that a school district is permitted to consult or partner with public, private, and nonprofit entities to provide assistance to students and families in reducing those absences. So you can go out and work with other entities to try and build that into your policy and try to assist these students with getting to school and reducing those absences. Further changes also include that chronically absent is now statutorily defined as missing at least 10% of the minimum number of hours required in the school year. And you're no longer required to prohibit the grade level promotion of a student that has been truant for more than 10% of the required attendance days of the school year. So, as we know, right, attendance is a good indication of success, but if a student is succeeding and is ready for the next grade level, you don't have to hold them back because of the truancy issue. And that was, previously one of the requirements in statute. Further changes also include eliminating timelines for filing complaints in juvenile court, and requires complaints only if the school district determines that the student is not making satisfactory progress in improving student attendance. Interestingly enough, the statute didn't change a whole lot. It still has the, 30 or more consecutive hours, 42 or more in one school month, or 72 or more in a school year that were in there that required a complaint to be filed. They still have that portion, but there's a second part of the statute now that says you can disregard that, and it's based upon the school district's judgment. And then finally, a filed complaint must allege that the child is an unruly child for being a habitual truant, and that the parent or guardian has violated the duty to cause the child to attend school. So a little bit of a change there, and being specific on what the complaint needed to allege. So we've got some additional changes to the release to time for religious instruction. So I think a handful of months ago we saw changes to release time for religious instruction, and then the Attorney General came out with some guidance in terms of how he felt this needed to be interpreted. Really, we see that guidance kind of being adopted in changes to this policy. So now school districts are required to permit students to attend a release time course in religious instruction for at least one period per week. The board policy on the opposite end cannot exceed 2 periods in total per week for elementary or middle school students, and the amount of time equivalent to attending 2 units of high school credit per week. So we've got some limitations on how much the student can attend release time for religious instruction, but also a minimum. Then this has been kind of not just in the Attorney General's opinion, but also I think in the news to some extent. Board policies cannot prohibit students from bringing external educational and program materials into school with them. So when they go out to their release time for religious instruction course and they're given items, the school district can't prohibit the student from bringing those external items back into the school. So we have kind of a pretty strong bill here, or a pretty strong change in legislation. This part of the bill establishes a state policy that recognizes only 2 sexes, and that's male and female. And they say that are not changeable and are grounded in fundamental and incontrovertible reality. And I think it's important to point out for this particular section that most of the time when we're looking at the organization of the Ohio Revised Code, we have oftentimes definition sections for each chapter of the Revised Code. I don't know that we oftentimes see, like we have here, a provision or a statute that requires or that defines specific terms for use throughout the entire Revised Code. But that's the avenue or the approach that the legislator took here. And so it defines the following terms for use throughout the Ohio Revised Code. And it's those terms are boy, girl, male, female, man, woman, gender identity, and sex. Gender identity is now defined to mean an individual's internal and subjective sense of self, disconnected from biological reality and sex, and existing on an infinite continuum that does not provide a meaningful basis for identification and cannot be recognized as a replacement for sex. I think the other thing to point out is that we saw some definitions for biological sex in the most recent bathroom bill and the Parents' Bill of Rights. Well, they take that specific definition of biological sex and use that as the definition of sex throughout the entire Revised Code. So the term sex and biological sex, as used in the bathroom bill and the Parents' Bill of Rights, now have the same meaning. We've got those definitions for male and female. Male means an individual belonging at conception to the sex that produces the small reproductive cell. Female means a person belonging at conception to the sex that produces the large reproductive cell. So those are the definitions that the legislator has chosen to use throughout the entire Ohio Revised Code. We've seen a lot in the Ohio, changing gears here a little bit, the Ohio Teacher Residency Assessment, RESA. We've seen a lot of changes to this, not only the RESA, but the RE program over the course of the last 4 years. I would say used to be 4 years, we're down to 2. Now this part of the program is being eliminated. So the bill eliminates the RESA as a measure of appropriate progression through the Ohio Teacher Residency Program, and permits the use of evaluations under a teacher evaluation system as a measure of appropriate progression under the program. It actually removes the provision in the teacher evaluation section that allows a board to elect not to conduct the evaluation of a teacher who's participating in the RE program, and doing the performance-based assessment. So because they're removing that performance-based assessment, they've removed the option for the school district to not do a teacher evaluation at that time. And then finally, and I think Sherri alluded to this a little bit earlier, we've got some changes to the State Board of Education. As you know, the Ohio Constitution requires that there be a State Board of Education. What that state board has looked like has changed a lot over the years. Currently, it is 8 appointed members and 11 elected. And this bill changes that from 11 from those numbers to 5 appointed members. So there's no more elected State Board of Education members. They're being removed completely. And then elected board members will serve out the remainder of their terms. And then the first 3 appointed members whose term expires or whose seat becomes vacated will not be filled. And then, the last part of this will work itself out over a period of time as the terms expire and new individuals are appointed. But each member must be a representative of either a rural, suburban, urban, or urban school district, a community school, and a charter school. So one member has to represent, one of those. So we have 5 members. We've got 5 categories. So each member has to be representative of one of those.
All right, well, thanks, Aaron, for that discussion. I have the pleasure of wrapping up our substantive discussion on 3 different subjects, 2 of which I think are going to have a pretty profound impact in terms of your labor relationships and what might happen at the labor negotiations table. So the first is relative to teacher assignments. I know this is one that a lot of people have been watching very closely and talking about. And this is if you've pulled the comparison document that was issued by the conference committee on the final bill provisions, you'll find this provision under the EDU CD 50 in that document. And this creates a new Ohio Revised Code section 3319-173. So this new section requires superintendents to assign teachers to positions based on the best interests of the students. That's the language that is used. And the plain language of the statute also states that this provision is applicable to assignments, reassignments, and transfers, whether any of those are voluntary or involuntary. And it also plainly says that seniority and continuing contract status shall not be used as a primary factor in determining assignments. And then also importantly, as is always in question in these kind of statutory changes, when you're talking about potentially affecting your labor agreements, the statute specifies that these new provisions prevail or supersede CBAs entered into on or after the effective date of this provision. And so the effective date of this provision, being non-monetary, is 90 days after the bill is signed. So we're looking at late September, early October in terms of the effective date of this bill, of this provision. And so in other words, if you have a CBA that's in place now and will remain in place, then the CBA provisions will control until the board and your teachers union enter into a new CBA that would be in effect on or after 90 days from the bill signing. So not surprisingly, the OEA did oppose this provision in the lead up to it being signed into law. OEA issued a letter addressing several provisions that it was challenging in the budget bill. And in that letter, it characterized this provision as abandoning objective standards and qualifications to guide teacher assignments. And as an example, the letter stated that this provision would allow teachers to be assigned without regard to the subject of grades for which they've been educated, and without confirmation that the teacher has the required professional development, such as science of reading or dyslexia instruction. So, my opinion of that is that is OEA kind of stretching the reach of this beyond, what really I think would reasonably occur. And I think that certainly, assignments will still be looked at based on teacher licensure and all of those other things. But certainly this does give a superintendent a lot more leeway in terms of determining who the best teacher is for a particular assignment. But I think consistent with OEA's position on this, what you're going to see is, I think, OEA attempting to dilute the provisions as much as they can, or wrestle back some control over the provisions, wherever they can. And we saw this, right, with the evaluation system when those changes were made to evaluations, that said that, preference could only be, preference could not be, preference for seniority could not be considered unless you had teachers that had comparable evaluations. So, on the tail end of that bill going into effect and those changes going into effect, you did see OEA coming to the bargaining table with a lot of provisions where they were trying to kind of strip back some of those rights. And I think we're going to see something comparable here. And I think we're going to see that first based on the bill language, that seniority and continuing contract status shall not be used as a primary factor in determining assignments. So when you when you use the word primary as qualifying the determination, that certainly leaves open the ability for a superintendent to consider seniority and continuing contract status as a secondary factor in looking at assignments or reassignments or transfers or voluntary or otherwise. So I think what we'll see is, your labor union is looking to try to solidify that seniority and continuing contract will at least be used as, a secondary factor over perhaps other factors. So I think you can look to see that kind of language during your next teacher negotiations. There is also the statute speaks in terms of assigning teachers to positions. That's the word that's used. So the term position can be defined very broadly and arguably would encompass not just a teacher's, main position that they're contracted for with the Board of Ed, but also encompass supplementals, summer school, that sort of thing. So I can see that there could be some push and pull in terms of how that term gets interpreted by the board versus how the union is going to believe that term gets interpreted. So I think you'll see you'll see some back and forth at the labor table on potentially that as well. And then, of course, as I mentioned, this provision prevails over CBAs entered into on or after the effective date of the provision, which is 90 days out. So some of you may be seeing your teachers unions coming to you to trying to roll over your existing CBA before this bill comes into effect, to try to avoid the implementation of this provision as superseding your subsequent CBA. So I would keep an eye out for that. So But in the meantime, my suggestion is that you look at your existing CBA and see what provisions you have in there that might be impacted by this statute, either negatively or positively, and really kind of start to get a game plan in place in terms of, okay, where does this impact our CBA, and what is the approach that we want to take with the union when they inevitably come to us about these issues. I do think it's also, this is interesting because this also may provide a district with an avenue. Like if you're looking at riffing, you may want to take a look at before you implement a riff, like are there assignments or reassignments that you might want to do before that riff gets implemented that may help you be able to implement that riff in a manner that's most helpful to your district. So I would keep that in mind too as we move forward and live with this language. Okay, next is a subject that I've already seen at the bargaining table. I don't know, many of you may have already seen it, but this is artificial intelligence. So as part of the bill, and this can be found at EDU CD 14 in the conference committee comparison document, and lives in Ohio Revised Code 330124. But what this provision does is it requires DO to adopt a model policy on the use of artificial intelligence in schools by the end of this year, December 31st, 2025. And the statutory provision specifies that that policy must address the appropriate use of AI by students and staff for educational purposes. And then districts have an obligation, they're required to adopt a policy then by July 1st of 2026. And this is an interesting dynamic because there's a must and a may in here. So districts must adopt a policy by July 1st of next year, but they may adopt a model policy developed by DO. So in other words, look at the DO policy, take from it what works for you, but you don't have to adopt the model policy verbatim from what comes from DO. So if you've been following AI at the state level, this isn't entirely surprising. Last November, there was an AI toolkit published by Innovate Ohio, which kind of came out of the Lieutenant Governor's Jon Hussed's focus on innovation, where it was a toolkit that was designed to address AI use in the educational world. So I see this as kind of a continuation of the state level focus on artificial intelligence. This is one that I think you've got to be very careful at the labor table. If you have your unions bringing proposals to you on AI. As I said, I've already seen it over the course of my teacher negotiations I did for my clients this past negotiation cycle. What I'm seeing is unions are afraid that AI is going to replace teachers. Where I think, the board and administration is looking at it a little bit differently. They're looking at it as AI is just another tool in their curriculum toolkit that can be used to better serve students and to assist, those human teachers in what they're doing. But it's my experience that unions are very nervous that AI is going to come in and just replace teachers and cause wholesale rifts and that sort of thing. So, with that concern, what I've seen is proposals at the labor table that would greatly restrict the board's control and management over its curriculum and how that curriculum is presented, and greatly restrict administration's ability to guide again programming and how curriculum is implemented at the school district level. There was one labor proposal at the table that would have had the board agreed, which the board did not agree to language, would have restricted administration from implementing any sort of AI without first bargaining it with the union. And so of course that would be a great abridgment of management rights. And so that's something that you have to be very careful about and should be very, very reluctant to agree to that sort of thing. Also, one of the problems with that provision was AI wasn't defined. And so then as we got into kind of a deeper dive of that proposal at the table, even the unions team wasn't able to really define with any sort of clarity what they considered AI versus what the board considered AI. And it was fleshed out in that conversation that there were at least certain people on the union's team that felt distance learning, which this particular school district had had in place for a course for many years, that they felt distance learning would qualify under AI. So you have to be really careful as you start to see these issues more and more at the labor table, to consider, okay, what does this really mean? How would this be defined? Are we thinking about the same way as the union's thinking about it? And is this something that works for our district or not? So, keep an eye out for that. But in terms of, anticipating the model policy from due at the end of this year and then implementing your own policy, I would suggest, that now you start looking at how you may be using AI currently in your district and how you may want to use it in the future, and start kind of being very thoughtful about those things so that when you get the model due policy, you're in a better position to determine what components of the policy may or may not work for your district or that you may or may not want to adopt. And then certainly, a component of that is looking at your CBAs to see if there's already any restrictions or parameters in place surrounding the use of AI in your district. Okay, last but not least, we have, probably a more straightforward change to the law. So this impacts youth suicide awareness and child sexual abuse educator training. This can be found in your companion document at EDUCD 97, and it lives in the Ohio Revised Code 33-19-073. So this is a statute that's been, that's existing law, and it's been in place for years now, and that addresses district's responsibility to provide suicide awareness and prevention training, and also training on child sexual abuse prevention and intervention. So what this does is it eliminates the requirement that develop a curriculum for youth suicide awareness and prevention for adoption by districts. Under existing law, or I should say, I guess, prior law until this bill, DO was required to adopt a model policy or a curriculum for adoption by districts. That's been eliminated, but also under existing law, the district could have developed its own curriculum in consultation with experts in the field. So that's been adopted. So now, in other words, districts must adopt their own curriculum for youth suicide awareness and prevention, and they must develop that in consultation with experts in that field. Also in existing law, there's training requirements for school personnel. So under existing law relative to youth suicide awareness and prevention, district and ESC teachers, nurses, counselors, school psychs, and admins must complete at least 4 hours within the first 2 years of employment with the district, and then every 5 years after. That provision is still in place. That's not been changed. But under prior law, self-review by those folks, a teacher, a nurse, or counselor, self-review of materials would have counted towards those training hours. That self-review component has been eliminated. So now, those folks that are subject to the training must actually undergo the training, and they can't just self-review and say that they've had 2 hours of it by doing that. So then shifting gears to child sexual abuse prevention or child sexual violence protection curriculum. The changes to the law also say that districts must develop their own curriculum in consultation, again, with experts, with public-private agencies or persons that are involved in those topic areas, the child sexual abuse prevention or child sexual violence protection. So again, now districts must develop their own curriculum in consultation with those experts. And prior law said that the training that has to occur with that, it needed to be provided by either a law enforcement officer or prosecutor. That is eliminated. So that training does not have to be provided by those folks, which means that, you now need to be looking at what the training is that you're going to be providing and who will be providing that training. Okay, so that's the end of the segment. We have quite a few Q&As that have been popping up. Let me try to get back to that.
Susan, even before the Q&As,
Sure.
these of us that were enjoying your presentation were texting about some things and thought maybe we would throw in a couple of little bonus tidbits from the
Okay,
bill that didn't make it into our slides. I'm going to
go
call
ahead.
I'm going to call Not It on hockey. So Aaron or Sherri,
Okay.
you can jump in with that if you want, or I can do my best from memory. There was in the budget bill, and either before or after the cell phone provision, there was a new addition about the provision of information required to parents upon their child's enrollment or at the beginning of the year, pursuant to statute, blah, blah, blah. And I said, well, what is that statute? And I went on a hunt, and the Department of Health is obligated to create basically an informational packet on type 1 diabetes for the purpose of informing educators, parents, and caretakers of children what signs and symptoms look like, to engage in kind of a screening and referral type process if there's a suspicion of a concern with type 1 diabetes. So given that the Department of Health still needs to generate that packet, we probably aren't looking at this until being something we are obligated to do until next year. But in the event that they do distribute this informational guidance before the end of this school year, and you have a student who newly enrolls, you would have to give it to that student's parent.
Okay. Great. So does anyone want to take the hockey subject?
Yeah, I can take hockey. So there's a for school districts that offer hockey, there's a new provision in the revised code that allows students who are enrolled in another district that is less than 20 miles from the home district, or from the district in question, right? The hockey district, we'll call it, that allows the student, if the superintendent permits, to play ice hockey on the other school's team if that school, if their home school doesn't have a hockey program. The superintendent of both districts have to enter into an agreement approving the student's participation, and it prohibits requiring a student to enroll in or be a resident of the district that offers the ice hockey program in order to participate in for that district. So it just provides flexibility for kids who attend schools that don't have a hockey program to play high school ice hockey.
So it does beg the question, who is a hockey mom or dad in the legislature?
Yeah, right.
Yeah, I don't know. Sherri, any ideas?
My guess would be Columbus or Cincinnati area. They're the ones that have the big teams.
Right. Okay. Any other topics that Kathy, Aaron, or Sherri, you want to address before we go to the Q&A?
Mm-mm.
Okay, so I think I'm going to do the Q&A kind of backwards. So we'll start with what was most recently discussed. So this one is probably a question for Aaron. Can the board policy prohibit, this is on release time for religious instruction.
Yeah.
Can the board policy prohibit students from distributing RTRI program materials to other students upon their return to school?
So this is not really a straightforward answer here. If the district is going to prohibit the distribution of all material by students, then I think you have a position that you can take to say that they can't do that for the release time for religious instruction programs. I think you get down a bit of a rabbit hole here, though, if you try to prevent it just for that. I think there's probably some room to prevent students from distributing candy or food items. You know, we have allergy concerns for that. But really, you know, when school districts are prohibiting the distribution of literature, we're controlling speech. and we have to be really careful that it's not based on the content of that speech. And if it's specific to the release time for religious instruction, it looks like a content restriction and is probably not permissible. So you've got some flexibility maybe for like the food. If you want a blanket for all content, then I think you have a better position. Specific to release time for religious instruction, probably not.
Yeah, yeah, I agree, Erin. I think that I think you're spot on that. I think you have to be careful about regulating for content. Yeah.
And
Okay, and then
sorry,
go ahead,
even as to the
Kathy.
candy, I would say, you better not let the Hubba Bubba wrapped in a Bible verse be restricted, but the Hubba Bubba in cellophane can come through the door. So
Yes.
time, place, and manner restrictions are okay, but content usually is a danger zone that you should consult with counsel about.
Yeah, I mean, I would liken it to kind of the assessment of can certain community groups use our buildings? Well, if you're going to open it up for some, you got to open it up for all, you know. Okay, and then the next gets to the math enrichment portion. What grade levels will math enrichment be required?
So the statute itself doesn't specify a grade level, but it does indicate that the assessments that it references start at third grade. So the way I interpreted that is beyond third grade is when those courses need to be offered if they're available.
And I would look for some policy provisions being handed down to address the current policy that some of you might have for grade level and content area advancement to see how this provision is going to interface with existing policy. And if your policy provider doesn't reach out to you proactively, just keep in mind that that policy is out there for some of you. And you need to think about how that exists, because while it might be under this bill that it's intended for 3 and up, you might have a policy that reaches down to lower grades for that concept.
Okay. The next one is addressed to Sherri. Sherri, if you said I missed it, did the achievement funds, probably the wrong terminology, stay in or get removed? And then there was like a follow-up that referred to performance supplement.
Yeah, and after he asked that question, Aaron went through the performance supplement. It is in the bill and will be implemented in this fiscal year.
Okay, great. And then a question regarding the 5-year forecast after the vetoes. Does a 5-year forecast still become a 4-year forecast?
Actually, the 5-year forecast becomes a 3-year forecast. That provision stayed in place, so you will be working off of 3-year forecasts moving forward.
Okay, interesting. And then one more that just came in, clarification regarding scholarship programs. Current homeschool student has been accessing AUS. As a previous guidance, no scholarship available, but now they can access scholarship, but not until early October. Kathy?
Yep, and that's
All you.
yeah, it's because it's non-monetary, Sherri, correct? They're presumed to be in effect 90 days from the date of
Correct.
enactment.
Correct.
And while there are monetary ramifications, I don't think this becomes effective anytime sooner. So you will want to work with the family. A lot of families are very uninformed about the scholarship process overall, about how the funding works, about why their kiddo might be getting kicked out now that they're 18. So for the nuances of the particular situation that might be behind that question, I would consult with counsel about how to handle the impact of this new bill on that student situation.
Okay, and then we have one more that I accidentally skipped over, and certainly if anyone out there still has questions, there's still time, type them up and we'll address them. But for the list right now, this is the last one. Any data on the state covering the cost of reduced meals for the next biennium?
So the governor did propose requiring districts with in excess of 25% of their students being disadvantaged. Those districts were going to have to provide free lunch and breakfast for all of the students in the district, in the building. That language was removed. So there is no language in the budget bill addressing additional costs or additional coverage of lunch or breakfast for students during this biennium. There also was some language at one point in time about potentially making some differences in who was going to be able to access this and the kind of information they could collect off of these applications, and all of that was also removed. So current law stays in place for breakfast, free breakfast and free lunches or reduced lunches.
Okay, and then one more regarding the cell phone policy. What counts as the instructional day for the cell phone policy? This district's current policy allows students in high school to check their cell phones at their locker between classes. Does that count as during the instructional day?
So it's not defined, and some districts before this iteration of the requirement were in place were going with no cell bell to bell and allowing for that. I think you're still going to see the discretion. I think your policy services are probably going to give you options for defining instructional day. I think you would be well suited to analyze with your teachers, with your disciplinary data, what has been the problem, right? Have cell phones been a distraction in the curricular setting, or have they also been problematic in the hallways, right? And the more you can articulate to parents the basis for why you're selecting the policy options that you're selecting and why you're implementing the prohibitions that you are implementing, um, I think you're going to be much better off than districts who kind of just get something adopted to check a box and have angry parents about extreme restrictions, and you can't even articulate that it was a problem literally from the first bell of the day until dismissal time. So just take the time. You've now got a semester to do it. Originally, there was one version that could have gotten pushed through that had an October deadline for you all. But have those conversations, do that analysis. And I think with the option of prohibiting cells from even coming into the building, right? If you are a district that has had extreme disciplinary issues in relation to cell phones, you might want to consider going that big with your policy.
Okay. Oh, wait, I think we might have one more. Let's see.
But wait, there's more.
Yeah, but wait, there's more. You can get a set of Ginsu knives for just $9 if you register now. Okay, did you see any items that the legislature may look to override the governor's veto? I think you talked about this a little bit, Sherri, but you're on mute. Sherri, you're on mute.
Because you all are tired of hearing from me. I
Never, Sherri,
will,
never.
I would say that I will not be surprised if there are some overrides or attempted overrides. I'm not sure exactly what ones yet. I've been looking again at social media as this webinar has been going on, and there's a lot of traffic. So I could see there being some in the next 8 weeks. But what those are yet, I don't have a good handle on.
Okay, great. Okay, so I think that that's it. If anyone else has a question, please. Well, so now there is kind of a offshoot of this. Are there certain items that you think are more likely than others to be overridden? And I think you talked about this a little bit, Sherri, in the beginning, but do you want to touch on those again?
Um, yes, I think so. I do think that potentially there could be an override maybe on the replacement, the elimination of some of those levies. That one we may see some movement on. It's been around for a long time. So that may be one that is up. I could see an override on potentially the STRS, SERS contribution issue. We'll see how much they want to get into that particular one. You know, I
Sherri,
just,
that one had IRS problems, though, I thought,
yes, and
right?
it did, and that may stop
Yeah.
it. I'm just thinking of the concepts that I've heard a lot about. I don't think they will try to fix the 20 mil floor calculations with an override. That has, but they may. I mean, again, those are ones that have been around, and there's been a lot of contentious conversation over in the last 18 months to 2 years. So, your guess is as good as mine, but I won't be surprised to see there be a couple of overrides. I don't think, it was mentioned that the governor said he could count and he knew he would lose the income tax elimination. I think he is expecting there probably to be some in this space as well, but he wanted to be able to make a statement and stake out his claim.
All right. Now they're looking for the over under on a possible override of the 40% carryover cap.
Oh, wow. Over under.
That was me. They just asked.
Okay.
The
All
question was just asking
right.
if you thought that would be overridden.
I think what I would say there is I while I think they would like to, I do think there are issues around the mechanism to reduce the millage given the multiple counties that some of our school districts span. I know that one of their superintendents who I work with has his district in 4 counties. So that piece was never really addressed in the budget bill. Given that this 40% is specific, you have to reduce it. They may think they can get it through and they can do this, but I think that multi-county issue with the budget commissions being the mechanism is a problem, and I won't be surprised if it does not. I won't be surprised either way. If I was going to guess, I'm going to guess they may override that one because it would put a lot of money into taxpayers' pockets, or not a lot. I shouldn't say it that way. It would significantly reduce property taxpayers' liabilities starting in January of 26. So that one potentially they will do.
I mean, it is essentially like looking in a crystal ball. So,
Right.
but thank you for giving us at least your best guess on these things. So, with that, I see no more additional questions. Certainly, so our contact information is all up on this slide, but certainly you're encouraged to reach out to your own district legal counsel with questions, but we are happy to address any follow-up questions you may have, and you can reach out to us at the email and phone numbers that are indicated on the screen. Also, you will be receiving our materials subsequent to this through an email, so you'll have that in your inbox as well. But other than that, I just want to thank everyone for joining us today. I think at the start we had upwards of 90 folks in attendance, which is a great showing. We hope that this discussion has provided you clarity on, some of the key provisions of the budget bill and how they may impact your district. Our goal is always to support you all and the school community with timely, practical insights as you navigate these type of legislative change. Again, a reminder that this was recorded, and the recording of this with the presentation materials I just mentioned will be shared with all attendees and all registrants actually. So even if you weren't able to attend, or if you have colleagues that weren't able to attend, you can let them know that they'll be getting that email as well with the recording and the materials. And just on behalf of all of us, all of our team here today, we just want to thank you again for spending some time with us, and we hope you have a great day. Thank you, everyone.